I really would love to get a bit of a characterization of the major legal battles facing tech companies. You mentioned the ones in the US, obviously in the UK, and, the kind of depth of issues. Like, obviously, you've already mentioned anti-competitive behaviour in Australia, copyright. What is that breadth of legal challenge looking like, and what does it mean for us in Australia?
Yeah, for sure. So the US has got lots of different litigation on foot at various points. So obviously we're waiting, for example, to see whether there will be an order that Facebook be broken up. So the capacity for these large companies to be broken up potentially is one example that may be achieved through litigation, yet to be seen. The role, I suppose, of, in the US at least, content moderation is another. Section 230, which deals with content moderation in the United States as to whether a social media company is a publisher or merely a telephone line for information. There's a question about that, like what is the role of content moderation and responsibility of social media platforms for content? That's also in dispute at the moment through a variety of different litigation. Can it be protected by First Amendment speech? Could you say that social media companies have no responsibility for content moderation because of that? I think that's increasingly less the case, but that remains to be seen. So the nature of large companies, whether they've got a role in content moderation and the legal boundaries around that, those are two issues. Of course, what I mentioned before is the issue of copyrighted material and training large language models on that. It looks like Anthropic's in trouble. They've admitted to training on pirated material. The material that they obtained legally and then trained their large language model on is apparently fine within the scope of what is called fair use in the United States. I'm not sure that would be clear in Australia. We have a slightly more onerous test for the use of material, which is called fair dealing. It's more limited, the exception, I suppose, is what I would say, than in the US. And so even if it's found to be fair dealing in the United States, in Australia it's not clear that would fall within that exemption. So companies therefore are seeking the data mining exemption to allow them to use copyrighted works. But Anthropic may go down for using pirated works, at least in the United States. And then we do have a range of competition matters. The matter that I talked about before in terms of competition in the App Store is one, competition in search is another. Also, my firm has just issued a proceeding about competition in the ad tech industry, so looking at Google's role in the ad tech industry, because it has what would be described, I think, as a vertical monopoly in between publishers of ads and people purchasing that ad space. So these kinds of practices that have been ongoing for the last 10 or 15 years really are now coming under scrutiny from the courts and potentially resulting in a range of decisions that will go against tech companies and could be potentially very expensive, could also fundamentally transform their business model. If they have to engage in more onerous forms of content moderation or take more responsibility for what is published on their sites, I think that would fundamentally change their business model. I think also, obviously, the breakup of these large companies, it remains to be seen whether that will actually occur, because you do wonder whether if any of these large companies start facing scrutiny for anti-competitive behaviour that would give rise to a breakup, whether they would be subject to intervention from the White House remains to be seen. So it'll be interesting to watch how the political dynamics play out if some of these are very fundamental to the ways in which these companies run their businesses.